Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. There are certain assets that are divided in the divorce that are easier to divide. It's intuitive that they should be divided, and it's intuitive how they should be divided. For example, I don't know, there's a 10-year marriage, and 7 years in, we decide to make a joint savings account. And over the last 3 years, we've been putting money in the savings account. Now we have $20,000. It is intuitive that that was created during the marriage. The parties are saving it. It's in a joint account. And because of that, it seems to make sense. If we have 20 grand in it, 10 will go to him, 10 will go to her, and that's it. Very easy to divide. But there are also some assets where it's not so clear cut. For example, retirement assets. A lot of times people feel, well, wait a minute. This is a retirement asset that accumulated because of my years of service. Now, I worked that job. He did not work that job. Why should I split that with him? Number one. Number two, even if I were to split it, I can't get the money now. I'm not age eligible to take my pension. How on earth would I split that? So there's a couple things I want to tell you about that. Thing number one, if your instinct is that just because you did the work and the whatever accumulated there was from the sweat of your brow, that means you don't split it, your instinct is incorrect. I'm glad you're listening to the video. The retirement assets, it's not a question of who did the work that caused the asset to grow. It's a question of when was the asset accumulated. If that asset was accumulated during the marriage, guess what? It's a marital asset. It's going to be subject to division. If it's a 401k plan, for example, that has a value. That's easy to figure out. We look at it, we think, okay, at the time of the divorce, there's $150,000 in the 401k plan, $75,000 goes to you, $75,000 stays in the plan. Now, when we take the money out, potentially, it might be a taxable event, but we can roll it into another 401k plan or maybe an IRA. We can talk about how to do that so that you don't get nailed on the taxes. But that's how you would do that. But what if it's not a cash asset? What if it's just a situation that every year you accumulate pension money, and when you become pension eligible, that's what you'll get per month. So after 5 years, maybe you have eligibility, I don't know, for $500 a month. After 7 years, you have $1,000 a month. You've been with the company 15 years, you get a $2,000 a month. How does that work? Well, the answer is there is a way to divide it. We're going to look at the years of the marriage to make sure that it was accumulated during the marriage. Assuming for the purposes of this discussion that it was, we're going to enter a qualified domestic relations order. It's what attorneys call a QDRO or a QDRO, and that's going to name as an alternate payee come pension time the non-working spouse. And let's say we determine that the benefit is $1,000, so it should go 500 apiece, 500 apiece. That qualified domestic relations order will order the employer that at the time of disbursement, rather than give $1,000 to him, 500 goes to him, 500 goes to her as an alternate payee. And that's how that works. But there's no question that these are retirement assets that are going to be subject to division, and there is a method by which that disbursement takes place. And the message that I've just described is the QDRO method. If you have any questions about that, reach out, and we'll be glad to help you out.